Hello, everybody. Hello, she's a maker. Hello, C-Rex. I know you probably do. Hello, Nana Laura. I have got shiny forehead. I washed my face right before I came on, so can't help it. I've also got puppy. Hello, Ava. Who is the bestest good girl? Who is the bestest good girl? But you got to turn around. We've got to figure out a way to make this work. Because everybody wants to see Ava. Come on, Ava. Come on. Well, come on up. Come on. Yes, you're a good girl. Where are you going? Where are you going? The treats are over here. As you can see, I'm still with Dad. So, might be a couple more nights. Cricket! She's probably on Dad's bed. That's Dad's dog. It's Dad's guardian, Dad's best friend. Oh my goodness, you just can't. You can't. You jump down to take the treat and jump back up. You make no sense. You don't make a lick of sense. Oh, and you are drooling all over the couch. There you go. Metal rules. Hello. Good to see you. Oh no, she's never snacked out. Never. Oh, you sleep sweet, Linda Applegate. Thank you for stopping by, love. Hello, Catherine Gaston. You get Ava on the big screen. Right, Ava? Right, baby girl? Come say hi to Catherine. You can lick up the rest of your crumbs later. Come on. Oh, my goodness. Come here. Profile view. Okay, can I have my mouse now? You give me too much credit. No. Hello, Wire Mother. Good to see you. Thanks for coming. I've done it before, but hello, Shane. Yeah, I think I've only done it like a couple of times. So, but you know, I thought it'd be fun tonight. I'm so happy they did. All right, so on the 31st, I saw a guy named Bobby. And they had mentioned a couple of previous hearings. So I went through my archive and I tracked him down. And I put together a few of his hearings. And they all tie together. And it's quite the interesting story. And we get to watch it unfold right in front of our eyes. Oh, I am so happy. That brings me so much joy to know that you got a larger tablet and you can see everybody better. It really does. Oh my gosh. I'm going to have to cover the birdies. I'm so sorry, guys. Hey. I gotta put the blanket on them. Well, Ava's already the CEO. She runs this company. Yeah, where's Sir Philip when you need him? Hello, Sherry B. Yeah, Ava wins every time. I have had Paw Pet polls, and Ava has won every time. There's like, I think 7 or 8 parakeets, budgies. They were my mother's before she passed away. We've been trying to get someone to take them, cage and all. No one will take them. I think you would have voted Billy. Am I right? I think Billy thinks he runs everything. Yes. Oh, I know. They don't. We never got the chance to teach them anything, really. My mom has raised them all from egg. Like, quite literally little alien bird looking things. Oh, somebody said Esquire. You'd vote Esquire? Well, I haven't done the poll since I've had Esquire. I don't know. Let's see. No. Hello, my dog farted. Because, mine always does. Hello, Eileen. Welcome, sweetie. Okay, I'm going to put the case on, and I'm going to put the blanket on the birds. I'm so sorry, guys. I should have done that before I even started, and I completely spaced it. I don't think so, but you notice we never eat turkey eggs either. Too young to run the company. All right, I'll be back in just a moment. Yes, I will. Oh my goodness. Hold on, I gotta make a couple adjustments here and go mute.
Right under the TV, that table.
Motherfucker, I'm slapping the fuck out of this
Hey, who's using that kind of language?
Darth,
Who was that?
Bobby.
Bobby, was that you doing that?
Yeah, I was cussing at myself.
You were saying you're calling yourself those names and you're gonna slap it yourself?
Yes.
I don't buy that. Well, we need to wait a minute. Deputy, are you with him?
Yes, Your Honor.
Who was he talking about slapping?
The jailer, the night he set off the smoke alarm.
Well, it's not a good idea to threaten to commit a person crime as you're coming before the judge. Miss Gillette, Bobby Coe just joined us from the jail, and he was using MF and F words, threatening to slap someone who apparently is a jailer that was on duty when he allegedly set off a fire alarm. And that's why I was suggesting to him that that was not a good way to start the docket.
Well, I guess we'll get a copy of today's court hearing for Mr. Coe's new charges of criminal threat.
All right, Mr. Coe, let's take up your case. We're on the record in 2024 CR 170, State of Kansas versus Bobby Joe Coe, County Attorney Jill Gillette for the state, defendant Bobby Coe in person, in custody and pro se. Mr. Coe, you're charged in one count. It's called, let me double check let me look at the official language. You're charged with unlawful request for emergency service assistance. The state is alleging that on or about the 12th day of September, 2024, in Greenwood County, state of Kansas, Bobby Joe Coe did then and there, contrary to the statutes of the state of Kansas, unlawfully and knowingly make a request for emergency fire assistance, knowing at the time of such request there is no reasonable ground for assistance. To wit, caused fire alarm to go off in jail, raising concern for jail staff. And this is a Class A non-person misdemeanor. If convicted, you could serve, in addition to whatever your sentence remains now on whatever charge you're serving, another 12 months and pay a fine up to $2,500. Who has your attorney been that most often that's been appointed?
William McLennan.
Okay. You don't have any more felonies pending?
No, ma'am, I do not.
He had Shannon Cooper on his misdemeanors before, and then she was the contract attorney, so he would need Mr. McClendon now.
He was the one. He was the one that I had for my city stuff, Jill.
What about
Yeah.
his, what about our public defender contract with Richard Paw?
I don't know why there might be a conflict with Mr. Paw, but
Okay,
Is
Bobby,
he out of the same office as Chris Pate?
yes.
yeah,
Chris Pate was my ex-wife's attorney on our child case.
Okay, all right, very good.
has 24 CR 99 October 15th at 3:30. So he's already here in court on 3:30 with Mr. McClendon on 10:15. It's the case he's in custody on.
Wait a minute. Say that again, please.
He has a case October 15th, 2024 at 3:30 with Mr. McClendon as his attorney on the misdemeanor docket.
It's for what I'm sitting in jail on now.
I thought you were on a show cause right now. I thought you'd had your probation revoked. No?
No, ma'am.
No.
No,
He
it was driving while habitual. You sentenced me to 90 to 180 days.
He has a review of the time that you gave him.
Okay, so he is serving a sentence, but he's
Yeah.
set for review to see if he can get it modified. All right, and now he's got this charge of
This isn't
reporting a fire. Say that again, Ms. Gillette.
helping getting a modification.
Yeah, I know.
All right.
They do seem to know him quite well.
So we will appoint William McClendon as your attorney, if he can take the case, and we will set this for October 15th at 3:30, at which time apparently you and Mr. McClendon have a motion for me to reconsider or to grant you parole for the case that you've been revoked on.
I haven't been revoked. It's just, there
That
was
was
no,
the original sentence, all right?
yes,
Rephrase that. Now, let me rephrase that so we have a clear understanding. You are serving a sentence, and you and your attorney have filed a motion for me to consider letting you out early, reducing your sentence, paroling you, or something of that sort.
yes, ma'am.
And now you've got this new charge, and then you came in here threatening to slap one of the deputies and
Allegedly.
Allegedly, I heard that with my, you better not make me a witness in your case, Mr. Coe.
I apologize.
You're
I
gonna
was
be
just,
in trouble.
I was just a little irritated. You know what I mean?
You kind of are a witness, Judge, because you saw it. So I'm gonna have to order the tape of today.
Now, you ordered the tape and you called the deputy there, but if I have to come testify in your case, Mr. Coe, I'm not gonna be very happy with you.
Well, I'll make sure that does not happen, ma'am.
All right, I don't know how you're gonna do that, but
I don't either.
you and Mr. McClendon can work that out with Miss Gillette, but
All right.
anyway, we have to do what we have to do.
Yes, ma'am.
And I won't find you in contempt for talking like that in court, but you understand, we don't.
Yes, I greatly apologize, and I hope that I do not get files charged. I do not need any more trouble. I was a little irritated and aggravated.
All right. Anything further, Miss Gillette, on this matter?
No.
I apologize, Miss Gillette.
All right, better apologize to that deputy. She didn't need to be hearing that either.
I apologize, Mayla.
All right, you can go at this time, Mr.
All right,
Coe.
thank you. You guys have a wonderful day.
Your Honor, do we have a bond on this case?
Yeah, do we have a,
Well, he's not going anywhere because I think he's serving a year, but
no, I'm serving 6 months.
oh, 6 months, excuse me. All right. But we can set one. I'm thinking 5,000 cash or surety. Let's make that his bond.
Okay.
Thank you, guys.
You're welcome.
Have a good day.
The only person he should have been irritated with is himself.
Now, I believe we have just one left on the docket with 2 cases. We'll be on the record now in 2024 CR 99 and 24 CR 170, each captioned State of Kansas versus Bobby Joe Coe. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
William McClendon for the defendant, Bobby Coe, who appears from the Greenwood County Jail.
Now, counsel, this third case that was filed in which I was named as an endorsed as a witness, apparently, you've set that in front of, was it Judge Crum?
I think Judge Ricky kept it for himself.
Oh, Judge Ricky.
Judge Ricky.
Okay.
Yes, Your Honor.
Well, I don't know if anyone addressed these remaining cases with him as a possibility of keeping them together or not.
He kept the 170 case too, I believe. Am
He
I
kept
right,
the
Jill?
170?
That's what I have in my notes.
Correct. So he has 2 new cases. The only thing that's on for today is the review of, this is the 3-month review of him being in custody. You gave him 6 months in jail, and you said you would review it today to see if he could get out basically for good behavior. But while he's been in jail, he's racked up 2 new cases.
Well, and he was also supposed to have his mom drive him to treatment and complete inpatient. Did that happen? No.
I did not believe so, Your Honor.
Your Honor, the sheriff for the sheriff's department would not let that happen.
Probably because of the new charges.
No, this was the new charges.
It was prior to that, Your Honor.
All right,
Yeah.
Mr. McClendon, you're hired to speak for him. Why don't you do that? What's going on? Why did he not do treatment?
I know that the sheriff wasn't wanting to let him out because that's not really a valid reason for release in his mind, I guess. I remember I'd emailed back and forth, and I don't think it was ever specifically put in a court order. And so, in a journal entry, that is, I could be wrong, but I don't recall one. And
Oh, in the journal entry.
Well, the journal
It was.
entry was it was kind of choppy. It said mom, he could be released to mom, but I don't think it said why or something. And yeah, when I went back and looked at that, I thought, well, you know, we should have probably worded that a little more specifically, but
that was the reason why the sheriff was apprehensive about it. And I know, and I'll be honest with you, this is in July, Your Honor, and I don't remember quite exactly what happened, and it might have fell through the cracks, but
well, the sheriff doesn't usually overturn my orders. So I wonder if there's some misunderstanding. In fact, I've never known him to overturn one of them. Mr. Coe, what do you want to add on your own behalf?
Your Honor, I'm currently on Senate Bill 123 and I'm required to do drug treatment and report to my community corrections officer. Before, this was prior to me being sentenced. You know what I mean?
Well, that's why I was going to let you do it. But
You know
then
what I mean? And so when I come to jail and I talked to the sheriff, and the sheriff said that he wasn't going to allow me to do it. He wasn't going to allow my mom to drive me back and forth to treatment in El Dorado.
Oh, I thought it was inpatient treatment. No, I wasn't going to let you drive back and forth to treatment.
It was outpatient.
that's what it was.
It's outpatient.
Okay, well,
That's what it was.
the issue. There
Yeah.
is the issue. I understood that you were going to be inpatient. Yeah, I can understand why no sheriff would want to let an inmate just willy-nilly run in and out. That would defeat the whole purpose of being in jail. So, but since you've been in there, you have gotten into some new charges that you may or may not be guilty of. That'll be for Judge Rickey to decide. But at this time, I'm going to go ahead and just let you finish your sentence that I originally gave you, because I see no justification for cutting it in half. So that's my order at this time. And nothing further. We'll be in recess. Thank you all.
Does she testify?
These matters are pending in the District Court of Greenwood County, Kansas, both State of Kansas versus Bobby Coe. Case numbers 2024 CR 170, 24 CR 174. Jill Gillette appears as Greenwood County Attorney. William McClendon is Defense Counsel. Mr. Coe appears from Greenwood County Jail's Zoom location. This matter is set for status on both of these cases. I hope progress has been made since our last appearance on October the 15th. Mr. McClendon, what is the announcement you make at this time regarding these cases?
Your Honor, we'll be waiving preliminary hearing pursuant to a plea deal.
Okay, and obviously that's in 24 CR 174, the criminal threat case, correct?
Yes, Judge. And it's a global plea resolution, misdemeanor plea.
All right. There's not going to be a felony plea entered in the 174 case?
No, Judge.
All right. All right. Mr. Coe, you currently have a felony case pending, but it's court's understanding that you will not be seeking to have a preliminary hearing in that case. Is that correct?
Yes, Your Honor.
All right. And that there's apparently your intention to plead to misdemeanors today?
Yes, Your Honor.
All right. Let's get some clarification on this. What is the plea agreement that's been reached?
Judge, he'll be pleading no contest or guilty, Mr. McClendon.
No contest.
He'll be pleading no contest to amended count 1 in 24 CR 174, disorderly conduct using fighting words. The fighting words talking about wanting to slap and hit, or I don't remember what all the threats were. Deputy Blake Fisher is the deputy, put him in lockdown on the night he pulled the fire alarm. He made that threat during Zoom, and it was recorded on a Zoom video call. The Judge Webster was the presiding judge and heard and would have been a witness to. That was during the Zoom call on September 17th, 2024. And there was a jailer in the room that he was making the threatening comments towards and wanting to hurt Deputy Blake Fisher. Then the other case is the 2024 CR 170 false alarm. Mr. Coe ended up pulling the fire alarm in the jail, having to cause an investigation into the alarm. And he caused the officers to all have to respond back or have calls in and such. So requesting emergency services when they're.
Okay, just a moment. Is it contemplated that he's pleading to that charge as set forth in the charging document?
Yes, Your Honor.
Okay, you may continue.
So that's unlawful request for emergency service assistant. Causing concern about pulling a fire alarm in the jail when there's no fire present. And that's 24 CR 170.
All right. Mr. Coe, I'll address you personally again. It's the court's understanding that you would resolve the 174 case by pleading to an amended charge of disorderly conduct, a Class C misdemeanor offense, punishable by up to a $500 fine and up to 30 days in the county jail. Do you understand that?
Yes, Your Honor.
This court's understanding you're also going to plead no contest and accept conviction for unlawful request for emergency service assistance, a Class A non-person misdemeanor, which would be punishable by up to 1 year in the county jail and up to a $2,500 fine or both. Do you understand that?
Yes, Your Honor.
The court will note that from the prosecutor's earlier remarks made to the court that there is a factual basis for each offense. So I'll ask the defendant, Mr. Coe, do you now freely, knowingly, and voluntarily enter pleas of no contest and accept conviction for disorderly conduct in the 174 case and unlawful request for emergency service assistance, a Class A misdemeanor, in the 170 case?
Yes, Your Honor.
All right. The court finds that the no contest plea is a free and voluntary act on the defendant's part in both cases. There's a factual basis in each case. And then the court has made the defendant aware of the possible penalties as to each of the two cases. Court will accept the defendant's no contest pleas and find him convicted of the amended charge of disorderly conduct in 24 CR 174. Also find him, pursuant to acceptance of his no contest plea, convicted of unlawful request for emergency service assistance, a Class A misdemeanor, in case number 24 CR 170. Since these are misdemeanors, defendants pleading to will proceed to sentencing at this time. What are the prosecutor's recommendations regarding an appropriate sentence?
Your Honor, on both of the charges, my recommendation is they run concurrent to each other, but consecutive to his current sentence he is in on. He is currently in custody serving a 6-month sentence, and he's over halfway into it on a
Okay,
case.
what's the case number there?
Case number 24 CR 99.
All right.
He is serving the 6 months on that case. It's a driving while suspended case is what he pled to. So there's approximately 2.5 months to go on that case. My recommendation is going to be an underlying a 30-day sentence on each case to run concurrent at the end of his current 6-month sentence, extending his current jail term by 30 days. If he had pled to the felony, it would have a special sentencing rule that they're consecutive, but they are misdemeanors. So the court does have that as a discretion. Instead of it being a mandatory presumption that they be consecutive because they're committed while incarcerated. Court costs. I don't know if the court's going to put any counsel fee on him since he has spent the last 6. I don't know if he's on one of the work crews or not making any money, but court cost, booking fee. I don't know what other fees to ask for other than those two, and to have you review attorney's fees.
Very well then, Mr. McClendon, your recommendations regarding an appropriate sentence on each of these two cases?
Miss Gillette outlined what my understanding to the plea deal was, and I'd ask for the same recommendation, 30 days consecutive to his current sentence, but ran concurrent together.
All right. How much are your fees and the representation of this client on each of these two cases, Mr. McClendon?
In the 170 case, they are currently at 30, and the 174 case, they are at 144, but I think I have some adjusting to do to split the time on the both of those cases.
All right. Very well. Thank you.
So they're about 200 in total, not counting today.
All right. Mr. Coe, at this time, the court will address you personally and ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court.
No, Your Honor.
Very well. We'll pronounce sentence first on case number 24 CR 174 for the conviction for disorderly conduct, a Class C misdemeanor. The court will not impose a fine on that particular charge, but will order the defendant to serve 30 days in the Greenwood County Jail. Regarding case number 24 CR 174 for the conviction of unlawful request for emergency service assistance, a Class A misdemeanor, court will order the defendant to serve 30 days in the Greenwood County Jail. We'll run the time on these two cases as recommended concurrently with one another, but will run the 30 days consecutively to the sentence currently being served in case number 24 CR 99. Certainly it appears appropriate to this court, Mr. Coe, that you serve additional time because of the rather unnecessary and inappropriate crimes that you committed while in custody. Essentially, improper words, let's say, to an officer, and apparently pulling this fire alarm stunt. You're just complicating your own life by acting up while you're in jail, and I hope you realize that now.
Yes, Your Honor.
Essentially, because he's going to serve the time out, he's going to flatten his time on each of these two cases once he's out of jail after that additional 30 days. Court will be assessing misdemeanor docket fees in each of those two cases and booking and fingerprint fees on these two cases. In regards to the case originally charged as criminal threat, I trust that this is a bids appointment. Court will be assessing to the defendant a $100 bids application fee, but will waive legal fees. And because of his incarcerated status, the court will also waive attorney fees in the misdemeanor case. Now, you're going to owe this money when you get out, Mr. Coe. It's not going to go away. It's you've got 60 days after your release date to pay both cases in full. Any remaining balances that you haven't paid, I'll authorize to be sent to collections at that point.
Okay.
So the plan is you've got 60 days from time of release to pay in full. It won't be sent to collections until after the end of that 60-day period, but any remainder will.
Yes, Your Honor.
So I would just recommend you just hustle and get these cases paid off to avoid complications and further fees.
Okay.
All right. I'm looking at my notes. Ms. Gillette, is there anything further that the court needs to address on either one of these cases?
I can't think of anything else, Your Honor. Thank you.
All right. Mr. McClendon, anything further we need to address?
Not at this time, Judge.
You have any questions about the court sentencing orders, Mr. Coe?
No, Your Honor.
I hope that you can be successful for the remaining balance of your stay in jail and just quietly do your time in compliance with the rules of the jail.
Yes, Your Honor.
All right. There's nothing further then. The Bobby Coe matters will currently be in recess, and this meeting may be ended for all. At this
Thank
time.
you.
Naughty, naughty Mr. Bobby Joe Coe. Hello, Chris Sampson. Thank you for being here. Oh my gosh. Yeah, probably. Probably. He needs a spanking. Seriously, who walks into Judge Webster's docket talking like that? What did he think was going to happen? Seriously. Of all of the people that's not going to let it slide, it's going to be the woman who, keeps defendants on the Zoom to await the sheriff showing up at their door and take them into custody. You don't pull that with her. And you don't pull the fire alarms, because that's just dumb. Seriously, I wonder what he was trying to avoid. And I mean, he had to pull it to get out of something. Oh, he's just a dingus. You guys are so much fun. I gotta stop saying seriously. Oh, I watched that the case from the other night, and I caught it from that guy. All right, I'm gonna go back to the case.
The Court of Greenwood County, Kansas, case entitled State of Kansas versus Eric James Malone. It's case number 2024 CR 100. Chris Ambrose appears as defense counsel, Jill Gillette as Greenwood County attorney. Eric Malone appears from the Greenwood County Jail's Zoom location. What announcement is made regarding case status at this time, Mr. Ambrose?
Your Honor, I believe that today the plan will be to enter a no contest plea to counts 3 and 4 of the complaint. Count 3 being possession of drug paraphernalia, a Class B non-person misdemeanor, and count 4 being possession of marijuana, a Class B non-person misdemeanor. The balance of the complaint will be dismissed. And then as a condition of probation, Mr. Malone must be, the state and defense are going to jointly recommend an appropriate underlying with 12 months of probation, standard costs, and Mr. Malone must get a drug and alcohol evaluation and then follow the recommendations as a condition of probation at his own cost, because this won't be a Senate bill case because it's a misdemeanor.
Very well. Do you agree with Mr. Ambrose's statement to the court, Ms. Gillette?
Yes, Your Honor.
All right, Mr. Malone, you've been present and you've heard your attorney make an announcement that you would now intend to enter no contest pleas and therefore be convicted of 2 misdemeanor charges, both Class B misdemeanors, unlawful possession of drug paraphernalia, unlawful possession of a controlled substance, marijuana. Do you understand these things?
Yes, sir.
Understand that Class B misdemeanors in Kansas are generally punishable by up to 6 months in the county jail each and up to $1,000 fine per offense.
Yes, sir.
Right. Factual basis for these 2 charges, Ms. Gillette.
Yes, Your Honor. On April 11th, 2024, Deputy Taylor Cordell was westbound on US 54 highway just west of Eureka within the bounds of Greenwood County, Kansas. She noticed an SUV pulling a box trailer. It remained in the left lane throughout the passing zone for an extended amount of time before finally merging into the right lane without using a turn signal. She activated her emergency lights and conducted a traffic stop on L Road. We go from A to HH. She approached the vehicle on the driver's side and introduced herself, and he willingly provided a Kansas ID card only, and he had 2 infant children with him at the time. She checked his driver's license status, which came back as suspended. The suspended license led to and as revoked as well. And he also had a warrant out of Butler County to show cause, and they were informed that state records make note that he could have other issues. So Deputy Taylor Cordell took him into custody. Deputy Harris arrived and helped. As they were waiting, because of the infants, holding the infants, the canine arrived and did a free air sniff of the vehicle, alerting to the vehicle. He was found with marijuana that tested positive at the lab. And he also had paraphernalia with the marijuana. And that was all located in a black bag. He had 4 small plastic baggies, some tutors. He had a black glasses case with more small plastic bags in it. He had brass knuckles that were also seized at the scene. So the containers and the baggies and the tutors would all constitute drug paraphernalia, having been found with drugs.
All right, Mr. Malone, at this time, do you enter no contest, please, and accept conviction for unlawful possession of drug paraphernalia and unlawful possession of marijuana freely, knowingly, and voluntarily?
Yes, sir.
Very well. Court at this time finds that it will accept the no contest pleas made by the defendant. He's been made aware by the court of the possible penalties. There is a factual basis for each offense, and it is a free and voluntary act on his part. Court will find him convicted, therefore, of count 3, unlawful of drug paraphernalia, Class B, non-person misdemeanor, and count 4, unlawful possession of a controlled substance, marijuana, a Class B, non-person misdemeanor. All other counts of the charging document are dismissed pursuant to plea agreement. We'll proceed to sentencing at this time. What is being recommended by the state?
Your Honor, the defendant has a limited criminal history, and so usually when they have a limited criminal history, and I don't do felony diversions, so sometimes we give them a second chance to plead to the misdemeanors and dismiss the felony. In this case, when I do those, I recommend that the court order they have their drug and alcohol evaluation, follow all conditions of it as a condition of probation with a 12-month underlying sentence. Sorry, in this case, it's going to be a 6-month underlying sentence. This is a first-time marijuana. 6-month underlying sentence with 12 months of supervised probation. I usually recommend a probation fee, booking fee, court cost, court to inquire pursuant to Robinson of attorney's fees. It did start out as a felony, so there is a bids application fee and attorney's fees to consider. When we talk of these cases, I ask that they complete their treatment at their own cost and that they don't have any substance use during their term of probation. And there's also a KBI lab fee to reimburse the KBI. And they'll need to sign releases for their CSO. That would be the state's recommendation, Your Honor.
Very well. Mr. Ambrose, your recommendations regarding an appropriate sentence?
Yes, Your Honor. By and large, as to the underlying sentence and the probation terms and obligations, we're going to join with Ms. Jett, as that was kind of where we were at as to the agreement. Would note for the court that there's going to be about $900 in attorney's fees on this case by the time we're done. Would ask the court to inquire directly of Mr. Malone regarding his employment, because I frankly can't recall off the top of my head what his employment situation is, and we're separate from each other. But I will note that Mr. Malone has been in custody for a little bit, and he is going to be responsible for paying for his own costs related to drug treatment. So I would ask the court to make those considerations in determining what, if all, bids application and attorney's fees are assessed against him.
Very well. Mr. Malone, at this time, the court will address you personally, and I'll ask you, do you have any statements that you wish to make in mitigation of punishment here?
No, sir.
Do you have work opportunities if you got out of jail?
Yeah, I mean, I've been in contact with my old boss at the pool company, and he said when I get this all figured out and straightened out, I mean, he said I have a job available if when I get out.
Okay, is pool company mean billiards type of pool?
No,
or
sorry.
swimming pool?
A swimming pool, Wichita Pools
Okay.
is the name of the company.
And how much money do you make at that job when you're working it?
Usually starts me out about $15, $16 an hour.
All right. Very well. Court will pronounce sentence in the case. Regarding count 3, unlawful possession of drug paraphernalia, Class B, non-person misdemeanor, the court will impose 6 months in the Greenwood County Jail. Court imposes no fine. Regarding count 4, unlawful possession of marijuana, a Class B misdemeanor, the court imposes 6 months in the Greenwood County Jail, runs that time concurrently with the time imposed on count 3, and imposes no fine on that count. The court will grant the defendant 12 months probation to be supervised by Greenwood County Court Services. He's to follow standard conditions, obtain a drug and alcohol evaluation within 45 days of his release from jail, and follow the recommendations of that substance abuse evaluation. Substance abuse evaluation does need to be approved in advance by the supervising court services officer. Court will be assessing a misdemeanor docket fee, misdemeanor probation fee, booking and fingerprint fee, $400 restitution to the KBI laboratory, and a $100 bids application fee. Mr. Malone, given the overall amount of the other costs in the case and the fact that you've been incarcerated for a while, court's going to waive assessment of legal fees against you in this particular matter. You need to start paying $100 a month the first full month after you're released from custody, and every subsequent month until your case is paid in full. Again, that's a $100 a month minimum.
Yes, sir.
You have other holds on you right now, Mr. Malone?
I do not believe so, sir.
I'm going to release you right now from custody on to Greenwood County Court Services probation. I don't see any reason if you're going to get released today that you can't report in person to a court services officer before you leave the building.
Yes, sir.
Okay. So I'm going to direct you to do that and then follow their directions regarding any future reporting that they deem necessary.
Yes, sir. Thank you.
Okay. I'm going to check my notes here to see if there's any other sentencing related matter that still needs to be addressed. Ms. Jett, anything in particular the court needs to address here?
I don't remember if you said to follow conditions. I think you did say follow his drug and alcohol evaluation and get one, but that's
Yes.
what I'm asking for.
Okay. Make sure you get that evaluation scheduled as soon as possible, Mr. Malone.
Yes, sir.
And your probation officer can talk to you about approved providers. All right.
Okay.
Mr. Malone, where are you going to be living when you get out?
In Andover. I'm not
Okay.
sure of the address right now, but I can give it to my probation officer.
Okay. And that must mean you're going to move in with somebody who isn't.
Yeah, it's a house that they just so it's my brother-in-law. It's kind of complicated. It's my brother-in-law's grandma's house. They just got given to him, and I'm not sure of the address, but it's on like Andover and Andover Road Central.
Okay. Your brother-in-law's grandmother's house. Okay. All
Yeah.
right. Fair enough, Mr. Malone. Just as long as you have a steady place to stay that allows you to report to a local officer, that should be fine.
Yes, sir.
All right. Mr. Ambrose, anything further at this time?
That's it for me, Your Honor. Thank you.
Any questions about the court's orders, Mr. Malone?
No, sir.
All right. Good luck to you. I hope you're successful on this probation.
Thank you.
If there's nothing further, then the Eric Malone matter will currently be in recess, and this meeting may be ended for all.
And Judge,
Yes?
we have Miss Carson out in the hallway. What would you like us to do with her?
You have Miss Carson out in the hallway.
Or-
As far as I'm concerned,
Miss-
she should go to. She probably should just be in custody. She didn't appear for her scheduled court hearing this morning, Mr. Ambrose. What are your intentions here?
Well, if the court will allow us, the plan that we had is Miss Carson would be entering pleas of no contest to counts 1 and 2, and then getting her set for sentencing. However, you tell us what you want to do, Your Honor.
Just a moment, counsel.
Yes, Judge.
All right, were you going to go out and get her, Mr. Ambrose, or what were your intentions?
Yep, she's right in the hallway, Judge. I'd grab her right now.
All right, at this.
Surprise! The docket gets crashed by this lovely lady.
time, the court recalls the case of State versus Joanna Carson. It's case number 2024 CR 14. Jill Gillette appears as before as Greenwood County Attorney. Chris Ambrose appears as before as defense counsel for Joanna Carson. Joanna Carson was scheduled to be in this court at 11 o'clock a.m. this morning for court. At about 24 minutes after 11, the court declared bond forfeiture, bench warrant issue for her arrest, with her to be held on a no bond hold due to her failure to appear. Ms. Carson, I don't understand. You were in court when the court told you the time you needed to appear and where to appear at 11 o'clock this morning, and you weren't here for a substantial period after that. Why didn't you take your appearance requirement seriously?
I did take it seriously. It's just I didn't get here. That's last time. This is the first
Yeah,
time
I'm
I've
having
actually been to
difficulty
court.
hearing you, so please try to speak as clearly as you can.
This is the first time I've actually been to court and physically in court.
And so did you
So
misunderstand how long?
what am I supposed to get out of that, Ms. Carson's?
Yeah, where was that? That's what.
You didn't know where the Greenwood County Courthouse in Eureka was located?
Yeah, 'cause I'm not from here.
Where are you from?
I'm Arma, Pittsburgh, Kansas.
Well, I would think if you didn't know for sure where you were going, you would allow even extra time to make sure that you did appear at the time you were scheduled to. I mean, this wasn't an early morning appearance set. This was 11 o'clock a.m.
I left at like 8 o'clock. I still didn't get there. It was longer than what I expected.
She was running on Xanax time. She is on some significantly heavy downers. It's so obvious. I was screaming at the computer while I was editing this and just begging Judge Ricky to send her for a urine screen, take her into custody, something before she kills someone. If she's driving herself around like this, she's seriously putting people in danger.
What announcement is made regarding case status?
Your Honor, the plan today, if the court would allow it, is Ms. Carson would be entering a no contest plea to counts 1 and 2, driving under the influence, fourth or subsequent, a level 6 non-person felony, and count 2, possession of methamphetamine, a severity level 5 drug felony. Upon entry of that plea, the state would dismiss the balance of the complaint.
All right, there must be an amended charging document in this case. I have the original before me. Was the count 1 upgraded after August the 15th? Actually, I have the amended complaint before me, filed on August the 15th, alleging a Class B misdemeanor in count 1 and a level 5 drug felony in count 2.
Give me 1 second, Judge. I'm confused here.
Mr. Gillette, could you help clarify the situation? Has there been another amended complaint and information filed after August 15 of 2024?
Judge, we ordered many certified copies of documents of her history because there are prior cases. And so with the specific dates, I believe that the Class B non-person misdemeanor is correct.
All right.
And that's correct, Judge. I'm sorry. I was looking at the wrong complaint. It is correct. It's the admitted complaint's the one we're working off of, counts 1 and 2. Count 1 being a Class B misdemeanor.
It was like a month's thing within a year time frame, Judge. It was like it became a Class B, and just because of a very short time frame from her prior.
All right. All right, Ms. Carson, if you're going to plead guilty to a felony or no contest to a felony, I've got a number of questions I need to ask you regarding the taking of such a plea. If there's something asked of you that you do not understand, I'll give you the opportunity to confer privately with your lawyer, Mr. Ambrose, before going further. Let the court know if you need that time to get advice, okay? I also will need you to speak clearly with all your responses. I want to make sure all participants can hear and understand your responses to the court's questions.
Okay.
State your full legal name for the record.
Joanna Lee Carson,
How old are you right now?
48,
What's the highest level of education that you've attained?
high school.
Do you believe you're going to have difficulty understanding the legal concepts we're going to be discussing in court here today?
No.
Or have you ever been adjudged to be mentally ill?
Am I? I have mental problems. Yes.
Okay, so you have had a mental health diagnosis before?
Yes.
Because of that, are you on any type of mental health related medication?
I take Wellbutrin.
Okay, does that help your mental condition?
Yes.
Okay, do you feel impaired in any way as you sit beside Mr. Ambrose today?
No.
So you don't feel like you're under the influence of any drug or alcohol for that matter, correct?
No. Correct.
All right.
We all feel like she is under the influence right now, Your Honor.
So you believe, Ms. Carson, that your mind is clear and you have a full understanding of what's going on here?
I do.
I'm sorry, I didn't hear the response.
I do.
All right. All right. Did you receive a copy of the amended complaint and information in this case?
Yes.
You understand the nature of the charge of driving under the influence of alcohol or drugs?
Yes.
Do you understand the nature of the charge of unlawful possession of methamphetamine?
I do.
All right. Do you understand that when you enter a plea of no contest, you are not admitting that you committed these acts, but you're also not contesting that you be convicted just the same? Do you understand that?
Yes.
You understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to these charges?
Yes.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Ambrose, and that at such a trial you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes.
You understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could elect to testify in your case if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes.
You understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described.
I do.
Also understand that you have a right to a trial by jury. Before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes.
Also understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
I do.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes.
Do you further understand that you may appeal your sentence after entering pleas of no contest, but generally you may not appeal your judgments of conviction after entering such pleas?
Yes.
You understand the possible penalties that could be imposed as a result of these no contest pleas that you're attempting to make?
Yes.
Let's go over those. For the DUI charge in count 1, a Class B misdemeanor, that's punishable by a minimum of 48 hours in jail and up to 6 months in the county jail. and at least a $750 fine and up to a $1,000 fine. You understand that?
Yes.
Unlawful possession of a controlled substance, methamphetamine, is a level 5 drug felony. It's punishable by up to a $100,000 fine. Do you understand that?
Yes.
In addition to the fine, under the drug grid, under the Kansas Sentencing Guidelines Act, in the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. In the worst criminal history category of A, you could receive up to a 42-month sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. As you sit today, Ms. Carson, we do not know with certainty what your criminal history is. You better than anyone else here should know what your own criminal record looks like, but that will be researched by the Court Services Department, and based on the outcome of that research as of the date of your sentencing, that will determine where you fall along the level 5 drug line, and then you'll be sentenced accordingly. Do you understand that?
Yes.
You also understand that if you have a person felony on your record already, at time of sentencing, you'll be presumptive prison.
I don't have any personal feelings.
I'm
But
just
if you
telling
did-
you. Do you understand that if you did, you would be
Yes.
presumptive prison at sentencing?
Yes.
All right. Did your attorney discuss with you the concept of Senate Bill 123?
Yes.
Certain offenders, because of a high risk needs assessment score, combined with an assessment which finds that they have a high probability of substance abuse disorder, may be mandatorily placed into a state-sponsored drug treatment program, which would be a requirement that you would complete in the case. Do you understand that?
Yes.
I'm sorry, I didn't hear the response.
Yes, I do.
All right. In addition to any fine that could be assessed in the case, are you aware that you could be required to pay certain fees and court costs and restitution to victims, if any are owed, as part of your sentencing orders?
Yes.
You also understand that as a direct consequence of this plea, you'll be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision as deemed appropriate by the court at time of sentencing.
Yes.
You understand that both probation and post-release supervision periods start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes.
You understand that if there are any special sentencing rules that apply to you and your situation, Ms. Carson, that this could affect your eligibility for probation or otherwise affect your sentence.
Yes, I understand.
Now, have you had an ample opportunity to discuss your legal matters with your counsel, Mr. Ambrose, before proceeding here today?
Yes, I have.
You want any more time with him privately now before we go further?
I think we're okay to go further.
I didn't hear that.
I think we're okay to go further.
All right. Are you satisfied with the services and advice given to you by your lawyer?
Yes.
Now, this no contest plea that you're attempting to make to these two charges hasn't been based upon any threat or promises as to what this court will do in regards to your sentencing or any other type of threat or promise?
Yes. No, nobody's ever threatened me or nothing. No.
You understand that if there are any plea discussions or deals between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes.
All right. How do you plead to the charge in count one, driving under the influence of alcohol or drugs?
No contest.
And how do you plead to unlawful possession of methamphetamine, a drug felony, in count 2?
No contest.
All right. You can have a brief and concise statement regarding factual basis, Ms. Gillette.
Yes, Your Honor. In this matter on January 7th, 2024, the defendant was stopped by Deputy Blake Fisher. She was stopped on US 400 at approximately the 325-mile marker, which is within the bounds of Greenwood County, Kansas. The vehicle was lingering within the left-hand lane and the passing lane, and it continued eastbound towards the location. He observed the driver's side portion of the vehicle cross the double yellow line which separates the east and westbound lanes of travel. As the vehicle crossed the double yellow center line, the front of the vehicle listed above was facing towards the stationary patrol vehicle, which is a potential hazard. So he had noticed her there, and then he conducted a U-turn and went and stopped her. The above vehicle, her vehicle did merge into the right-hand lane without using its signal, and the vehicle then pulled partially onto the shoulder of the roadway, and the vehicle was half out in the southernmost eastbound lane of travel and not parked properly on the highway. After making contact with her, he determined that she was having some issues. He ran her through his in-car terminal to ensure there weren't any arrests, and through dispatch, any warrants out for her arrest, and she did have a valid license and no outstanding warrants. He did try to gather the insurance information and allowed her to make phone calls. She was not able to ever pull up any car insurance. She had informed him she had prior alcoholic and had 3 DUIs in the past, and that she had prescriptions and different things with her. The canine came to the stop as she was not free to leave and had a positive alert on the vehicle. A subsequent probable cause search revealed many different items, and they ended up taking her in and testing her. She ended up having a blood drawn done. The items tested at the KBI lab tested positive for methamphetamine with a pipe that she had. Then for her blood draw, she was positive for methamphetamine, amphetamine, buprenorphine, diazepam, nordiazepam, bromazepam, and those are all of the substances that were in her system at the time of driving and operating the vehicle upon 400 highway within the bounds of Greenwood County, constituting a combination of drugs that would impair the ability of the driver to be able to drive a vehicle.
And I bet you if you did an analysis on her right now, it would probably mimic that buffet.
Very well. Ms. Carson, do you now freely, knowingly, and voluntarily enter pleas of no contest and accept conviction for driving under the influence of alcohol or drugs, a Class B non-person misdemeanor, and unlawful possession of methamphetamine, a level 5 drug felony?
I do, yes.
Mr. Ambrose, do you know of any legal reason why the court should not accept your client's pleas?
No, Your Honor.
Mr. Gillette, are you aware of any such legal reason why the court shouldn't accept her pleas?
No.
All right. Ms. Carson, are you aware of a legal reason or any other good reason why the court shouldn't accept your pleas here today?
Because she's loaded.
No.
When your attorney has to like cattle prod you to get you to answer the judge, there's a problem.
Okay. Court will accept the no contest pleas made by the defendant and finds that those pleas are made voluntarily. She has an understanding of the nature of her charges and the consequences of her pleas. The factual basis for the 2 charges does exist. Court finds her guilty and adjudges her therefore convicted of driving under the influence of alcohol or drugs, a Class B non-person misdemeanor in count 1, and unlawful possession of methamphetamine in count 2, a level 5 drug felony. All other charges of the information are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Ms. Carson's criminal history, and the court will set an appropriate date for sentencing. Thursday, December 26th,
Okay, that works for us, Judge.
11 o'clock a.m.
That works, Your Honor.
Ms. Carson, that's 11 o'clock a.m. Central Time. You're not allowed to be late. Now that you know exactly how long it takes to get to Eureka from where it is that you live, you should have no trouble getting here early and being available to the court when I want to start court at 11 o'clock on Thursday, December the 26th. I want to set aside the court's earlier order regarding bond forfeiture, bench, and no bond hold, reinstate or prior bond. With some hesitancy, Ms. Carson, I just don't know if you take this whole thing seriously or not.
I take it very seriously. I
No.
just didn't realize that part.
11 o'clock a.m., Thursday, December the 26th. Defendant is ordered to appear at the Greenwood County Courthouse in Eureka, Kansas to participate in that sentencing. 11 o'clock, Thursday, December 26th. I won't approve that you would participate from any other location but the courthouse. All right, Ms. Carson?
Yes.
The court also ordered the defendant to fully comply with any requested risk needs assessment or substance abuse evaluation, which is requested of her as part of the pre-sentence process. I'm going to need Ms. Carson to contact the Greenwood County Court Services Department before she leaves the building. Mr. Ambrose, if she doesn't know the way, could you show her?
Yes, I can, Judge.
Okay. And then follow their direction, Ms. Carson, regarding what you need to do to facilitate and complete the pre-sentence investigation process. Okay?
Okay.
Ms. Gillette, anything else we need to address at this time?
I can't think of anything else, Your Honor. Thank you.
Mr. Ambrose, anything further currently?
No, Your Honor, thank you.
Ms. Carson, do you have any questions about what we've done here?
No, sir.
Okay, you're going to go talk to a probation officer, court services officer, as soon as we get done here. Don't leave the building until that conversation's taken place, okay?
Okay.
All right.
One
There's
question,
nothing-
Judge,
Go ahead.
if that warrant is still in your queue or with the clerk's office, we just ask that one of you reject it back to us.
Court will do that.
Thank you.
Thank you, Judge.
This is in the District Court of Elk County, Kansas, case entitled State of Kansas versus Jett T. Hazelwood.
Yeah, I wonder if Judge Ricky has a plan. He is sending her for the pre-sentence investigation report right away. She's got to talk to probation. So maybe he's waiting for them to cue in on it and demand an immediate drug screen from her. I don't know. But that woman was absolutely lit. She was, and that's possible too. He could be setting her up knowing she'll fail and giving him grounds to put her in for longer. I don't know. I don't remember what she was facing in terms of time. But if she doesn't show, or if she just leaves the building or something like that, then she very much has more time. Yeah, she's going to take a life, either hers or someone else's. Yeah. At the pharmacy, it's all behind the counter. With her, it's all in her bloodstream. No. Seriously, she did not take it seriously. Sorry, couldn't resist. Had to. Right? I don't know. We can't really say she was high because I'm betting anything. I will put all my chips on every one of those was a downer that she had in her system now.
Case number 2021 CR 20. Eric Hartenstein appears as counsel for Mr. Hazelwood. Mr. Hazelwood appears from the Elk County jail location by Zoom. Jill Gillette appears as Elk County attorney. This matter comes before the court at this time for further hearing in regard to probation matter. There is a warrant to show cause pending, alleging that the defendant had failed to maintain contact with his intensive supervision officer, and at that time of the warrant, the defendant's whereabouts were unknown. Mr. Hartenstein, I trust you're ready to proceed here?
Yes, Your Honor.
All right. I know you said you were going to make some statements on the record. Do you need to make those now, counsel?
Yes, Your Honor. As a matter of preliminary matters, I did have an opportunity to speak with Mr. Hazelwood here. He reached out to my office at some point in the last month or so and left a message. I believe I tried to call him back, but I never did achieve contact with him. I didn't really know his whereabouts. Regardless, in our conversation right now, he reports that he's uncomfortable with me proceeding as his lawyer. He would request a different lawyer moving forward, and his reasons for requesting a new lawyer would be primarily lack of communication, lack of cooperation with regard to how to proceed with his case. He doesn't feel like I treated him fairly some years ago when we pled this and sentenced this case. Frankly, Your Honor, I don't remember a whole lot of the procedure, but I did look at the pleadings and the paperwork, and I felt like we did what we were supposed to do in this matter. But I think in interest of protecting Mr. Hazelwood's rights, I'd ask you to withdraw me and appoint new counsel for him.
We should obviously delay these proceedings. In the meantime, Mr. Hazelwood remains in custody. Mr. Hazelwood, court has to make a finding here that there's justifiable dissatisfaction with your attorney. What is your position here?
I feel like he made me take a plea that, like he said, if I took it to trial, then there was no way that the jury would say that I'm innocent. So I would be better off if I would take a plea, and I would get less time in jail. And
But this all goes back over 2 years ago, though, Mr. Hazelwood.
Yeah, I know. I even told Ken, I said, I hope they do not give me Eric Hartenstein, because he did not help me at all in my court. When we had court, and I felt like I was just like a sitting duck that couldn't say anything. I couldn't get a word out. No matter what I did say, it didn't matter. And there was times where they had no evidence on me at all. No hard evidence whatsoever on me even doing the crimes. And he never stood up for me and said that. And he never pointed out. He did one time, but then he didn't say anything else. And it was just like, okay, he stated it, but and then the very first time I ever talked to him, my girlfriend at the time got mad. She didn't get mad. She kept like saying stuff in the background to kind of overtalk, and he got mad and like kind of yelled at me and told me that he wasn't going to be my lawyer, and that my next court date, expect somebody else there. But he was there and he never helped. It was like,
all right, Mr. Hazelwood, do you realize that we're not going to go back to 2022 here?
I'm not trying
that
to.
What we have before us now is a probation revocation matter. We're dealing with your probation status now. The time for plea and conviction has long passed.
Yeah, I know that. I'm just saying, I'm not comfortable with him being my lawyer whatsoever.
All right. Well, I think the position, which was, I think, tactfully espoused by your attorney, certainly has been borne out by the comments made by Mr. Hazelwood. Mr. Hazelwood, I think you may be actually compromised by a delay, and I hate to grant this. We can't just give you another attorney, have him prepared and proceed right now. So I'll have to set this off. And I will go ahead and relieve Mr. Hartenstein as your attorney.
Okay.
We will appoint you a new lawyer.
I really
As I trust you can't afford to hire your own, is that right?
No, I can look into it. Supposedly, some of my
Well-
family are lawyers, but I gotta try to get a hold of them and talk to them. But I mean, I
All
can
right,
try.
well, I'm
But-
going to appoint a lawyer to represent you. If you want to replace that appointed lawyer with one retained by
Yeah.
you or your family, fine. But I
Okay.
need to have a lawyer on board for you by the time of our next hearing.
Yep, you can see if your cousin Vinny will tell them that there's no evidence against you for the crimes that you committed. It's about what you said. Was your complaint against the other lawyer?
Right. I really.
Randy, can you suggest the date and time on the November calendar for Mr. Hazelwood's case? Or is there one?
We can do 3 or 4 p.m.
And the date?
November 27th, Wednesday, November 27th.
All right, that's the day before Thanksgiving, right?
Correct.
All right, Wednesday, November 27th at 3 o'clock be the new date and time for hearing on this warrant to show cause matter. November 27th, a Wednesday, 3 o'clock p.m. by Zoom. We'll appoint new counsel for Mr. Hazelwood. I trust that attorney will be in contact with you or will make an attempt to get in contact with you between now and the time of that next hearing in November.
Okay. Do you guys need my phone number, or is there somewhere I can update it to?
All right, are you in custody or out of custody?
What do you mean?
Okay, you're not in the jail facility right now, right?
No, I'm in the jet. Like, no. I came up here, like I drove up. No, I didn't drive up here. My girlfriend drove up here.
Okay, all right, fair enough. You're out on bond, in other words.
Sorry, sometimes I can't get things out of my mouth. You know what I mean?
Yeah, I don't think it would hurt one bit if we had your phone number stated.
Maybe you don't want to be put in jail because they'd love you for that.
Mr. Hazelwood.
Okay.
So go slow and just state it for us.
It's
All right.
Yep.
That phone number will be passed along to your new attorney.
Cool. Awesome. I really appreciate it.
Now, I'm going to order you to appear right where you are today at the Elk County Sheriff's Office for this next hearing. All right, Mr. Hazelwood?
Yeah, do you have a pen I can borrow fast? What was that date again?
It's November the 27th at 3 o'clock p.m.
Judge,
Day before Thanksgiving. Should be easy to remember.
I don't know that
There you
Mr.
go.
Clausing has a current address because I don't know that he's had any contact with the defendant since he absconded. So I would ask that he be put in a breakout room with Mr. Clausing.
Okay.
Are you not next door?
If Ken wants that, I'll do that. But Mr. Hazelwood, I'm going to ask you, what is your current residential address?
It is in Independence.
All right, in Independence, Kansas. All right, very, very good. Do you want a breakout room with Mr. Hazelwood, Mr. Clausen?
Yeah, because I'll be in Howard on Tuesday, but or Wednesday. I don't know if he'll make it. So yeah, that'd probably be best to do in a breakout room.
All right, Mr. Hazelwood, we're going to go ahead and recess court. I'm going to release Mr. Hartenstein and Ms. Jett, but we're going to leave the meeting open so that you can meet with Mr. Clausing for a moment by Zoom. Follow whatever direction he gives regarding reporting to him or anything like that. Okay.
Okay.
All right.
All right. Thank you.
All right. Then I'll go ahead and release counsel at this time.
Will now be on the record in 2024 CR 117, State of Kansas versus Brandon Devon Harris. County Attorney Jill Gillette for the state. Brandon Harris, if you'll start your video, please. Thank you, Mr. Harris. Let's see. You were first here July 25th of 24. You were going to look into diversion. You were back July 30th of 2024. You'd been denied diversion, so you were going to hire an attorney. You were here September 10th, 24. You were going to hire an attorney. You were here today without an attorney. What is your plan, sir?
I'm just gonna proceed with myself. If I can find a attorney in the future, I will. But I found one, but then the job that I started working, something went wrong with that, so I had to come back home.
Yeah, well, I'm not inclined to keep continuing this. Do you have a job right now?
Somewhat, yeah, you could say I do. You could say I do. I only been here for what, 4 days back home. I came back last Thursday, so I haven't went to work, but I have somewhere to work. Yeah. Yeah, you could say I do, yes.
Well, my point is, are you going to apply for court appointed?
Yes, I guess so.
So how long has it been since you worked prior to this job?
Just last week. It was just last week.
What'd you do up until last week?
No, I just got home Thursday.
Right. Well, I'm going to appoint attorney Richard Paw, P-A-U-G-H. You have a pencil to write down that number? Always, always, always come to court with pencil and paper. Mr. Paw's number is, that's Richard Paw, P-A-U-G-H. And Missy, what court date do you want to give him?
Let's schedule this one for November 19th at 3:30.
Okay, you get a hold of Mr. Paw and be back here November 19th. You said 3:30?
Yes, please.
Let's try to get this wrapped up. Either set it for trial or set it for plea, but let's quit dragging it out.
Yes, ma'am.
All right, if there's nothing further, Ms. Gillette.
Nothing further from the state, Your Honor.
All right, Mr. Harris, did you make a bond?
No, ma'am. I was never arrested for anything.
You need to contact our sheriff and get your picture and prints taken. Call our sheriff at 620-583-5569.
Judge, you gave him $1,000 OR bond at his first appearance and told him to be processed then. And he hasn't done it.
You didn't go do that, Mr. Harris?
What?
You didn't go over there and do what I told you to, get your picture and prints taken and make $1,000 bond?
No, I wasn't arrested for anything.
No, that's why I ordered you to go get your picture and prints taken and gave you $1,000 bond at your first appearance.
No, ma'am. I haven't been back to Kansas. This is in Kansas. I haven't been back to Kansas.
Well, maybe I just need to send the warrant out for your arrest. Because I told you June 25th to do that. Where do you live?
I'm in Georgia.
I'm going to give you till the next hearing to get that done. And if you don't, I'm going to order an arrest warrant. And
Okay.
I'll have the police go get you if necessary.
Okay.
Get that done. You ask Mr. Paul if I'm serious about it. He'll tell you. All right. You may go, sir.
All right. Thank you.
You're welcome.
Ooh, yeah, I think she was pretty serious about that. And I did not even notice that until you said something. It was confusing. You are so right. Oh, you guys have been absolutely wonderful tonight. I had so much fun with that. No, I get it. Yeah. When you said it and I looked, I couldn't tell if it was the shape of his chin or if he had like face fur growing there. I don't know. Yeah. Hello, so Liz, honey. Thank you. So happy to see you. Unfortunately, we just got done running all the cases that I had prepared. Oh, it's hard to get. It's hard to life right now, and that makes YouTubing, so much more difficult. But made a lot of progress today with Dad, so I'm proud of him, and he's trying. He's putting in a lot of work to get better. Oh, I love you so much. You guys are so wonderful to me. You absolutely are. Such a blessing. Such a blessing. You guys make me so happy. And thanks to Mortimer Duke, I can DoorDash 96 ounces of Karuba coffee to go. I might actually just wait for morning to do that. I think I'm going to just crash for tonight. And I'll get coffee in the morning. You know what that means? Do you know what that means? Happy birthday, la 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 la. It's your birthday, yay, la 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 la. I love you so much. Happy birthday, sweetie. You know what? I've got a lot of people praying and sending good vibes and well wishes and all of that magic. I really, truly think it does help. It's in my rearview mirror too, by a decade. I know. I feel it. I feel you guys every day. All right, guys, I'm gonna take Ava's lead here. She's showing me how it's done, and I'm gonna get some sleep. If you can't tell, I need some beauty sleep. Yeah, it's been a rough week. And I gotta find good stuff for tomorrow. Happy birthday, Sobe Liz. We all love you. You guys have a wonderful night, and I'll see you again soon. Be safe, be well, sleep sweet, and much love.